So this is our fourth video in the Enduring Power of Attorney series, and this week we look at what happens when you feel that the person who appointed you as their attorney has lost mental capacity. Well, firstly, there will be circumstances around that which will lead you to believe that they genuinely have lost mental capacity. There most likely will be medical attendances and so on. So when you believe that to be the case, the legislation imposes an obligation on you at that point that you must go and register the enduring power of attorney that your loved one signed, who knows when, but whenever they signed it appointing you, and you'll have signed it so you'll know that you are an attorney. Now I'm talking as if there's only one person, but there could be more than one of you. Anyway, when you believe they've lost mental capacity, you must make an application to the Office of Care and Protection in the High Court to register the document. Now, that can be done with legal assistance or without. It's not complicated at all, but you might want to avail of legal advice. Now, the process of doing that, the first step is you make an application to the High Court, simple, straightforward form. And then the second stage of that process is you must, and at the same time, serve notice upon a certain class of relatives. Usually if you're applying for a parent, it'll be on your brothers and sisters. Maybe if this is for your mum and your dad's still alive, it'll be on your father. Basically you have to serve on them confirmation that you have, as the person's attorney, you believe they've lost mental capacity and you're now formally registering the power of attorney with the High Court. So to do that, you have got a small fee to pay. At the minute it's about £130–140. It's not very expensive, but you serve that and on those relatives, and then you put the application into the High Court. Now, the High Court will, the Office of Care and Protection within the High Court, they'll wait a period of 35 days, and the reason for that is they want to see, is anyone objecting to you making this application? Now, it could be that the person hasn't lost capacity. This is why they put these safety mechanisms in. There may be relatives who disagree with your view on this or whatever, but generally it's to make sure that someone isn't being granted a power to deal with another person's financial and property affairs who hasn't actually lost mental capacity. So again, the legislation puts these safety mechanisms in, and you're obliged to follow them. Okay. Now, if everything goes to plan and the power is, the court stamps and approves it and appoints you as the attorney from that point to legally deal with their affairs, then you have got to adhere to the provisions that are set out in the legislation governing powers of attorney in Northern Ireland. So be careful not to overstep the mark in terms of how you deal with somebody's property or financial affairs. You must act in accordance with the law, and if you have any queries at all in terms of what you have to do or want to do, you should take legal advice or indeed make contact with the Office of Care and Protection. So if you need any more information about what to do, if you believe that your loved one has lost capacity and you are an attorney appointed through the enduring power of attorney that they signed, then contact ourselves or through any of our social channels or through our website, or just make contact with the office to arrange an appointment if you want to discuss any further.